Hello, my friends, and welcome to the Personal Responsibility Lawyer Podcast. I am your host, Michael Lovins of the law firm Lovins Trosclair, which sponsors this program. I'm delighted today to welcome Clark Neily to the program. Clark is the Vice President for Criminal Justice at the Cato Institute in Washington, D.C. He's an expert on lots of things, and he has a great book called Judicial Engagement. It's not new, and he's not on to talk about that, but I highly recommend it, even though we're not really going to cover any of those topics today. Today, we're going to talk about the process of getting from indictment to either conviction or acquittal, and some of the stuff that happens behind the scenes in that process. So first, Clark, welcome to the program.
Thanks very much. Glad to be on.
First of all, tell us, so you're Vice President of Criminal Justice at the Cato Institute. Give us just kind of a brief overview of what that means. It's not a title that you would normally have at a non-think tank sort of company. So what exactly does that mean?
Right. Well, so the Cato Institute is the country's premier libertarian think tank. We've been around for just over 40 years. And basically the purpose of the Cato Institute is to come up with essentially libertarian-based suggestions or policies to improve the state of affairs here in the U.S. And one area that is very much in need of improvement is our criminal justice system, which I believe in a nutshell is fundamentally broken and deeply pathological. And so it is an area of public policy in America that is desperately in need of fundamental reform. And my job is to essentially try to analyze the basic problems and come up with proposals for reforming the system so that it can regain its political and moral legitimacy.
And so one of the things that, and this is the main thing I wanted to talk about today, is it's the plea bargaining process, which I think most of us who aren't involved in the criminal justice system on any level, I'm a lawyer, but I do civil cases, and I don't ever see a criminal case. I don't want to see a criminal case. And of course, I certainly don't want to be a criminal defendant. But what I think of in the criminal justice system, at least we'll cut out the police part. You get arrested and you get indicted, and that's kind of where I want to pick up the process to some extent. Now, I think there's a little that happens before that that's important, at least for what we're talking about today. But then I know most of these cases don't go to trial. A jury doesn't decide them, but you just work out a deal between the prosecutor and the defendant, and it seems voluntary and it seems pretty simple and nothing that I really ought to be concerned about. But I think from what I've heard you say in various forums, there's a lot to be worried about. Why?
Well, let's start from the beginning. The constitutionally prescribed mechanism for resolving criminal charges in this country is a public jury trial. That's what the Constitution provides. Plea bargaining is nowhere mentioned in the text of the Constitution. That doesn't necessarily mean that it's illegitimate, but it is not something that was contemplated by the founders. And we know that for two reasons. First, because they said nothing about it in the text of the Constitution. And second, because the practice itself, the practice of resolving criminal charges through plea bargain, was completely unknown at the time of the American founding. And so the basic issue with plea bargaining is that it has taken on such a prominent role in our criminal justice system. About 95% of all criminal convictions today are obtained through plea bargains. So it's the default mechanism now for resolving criminal charges, not the constitutionally prescribed mechanism, which is the jury trial, but instead this ad hoc approach to resolving criminal charges, the plea bargain. And so then the question is there a reason to be concerned about the way that the plea bargaining actually works in real life? And there's basically two different narratives. The narrative you'll get from prosecutors is there's nothing at all to be concerned about. This is nothing more than just giving defendants who choose to confess their guilt and spare the government the expense and inconvenience of a trial a bit of a break. So, for agreeing to do that, and you're still perfectly free to go to trial if you wish. That is a completely false picture of how it actually works. In fact, plea bargaining has become extraordinarily coercive in this country. It's very difficult to draw that line, and it's very difficult to say how much plea bargaining is coercive, but clearly a great deal of it is, for reasons we can get into in a moment.
Well, when I look at it, before I heard the things that you and some of the others in this kind of the criminal justice reform and plea bargaining reform movement I don't like the word movement, but I don't have a better one right now. It doesn't sound coercive. The defendant is agreeing to it. He has a right to go to trial. How is that? How is the process how has it become coercive, and how did it get that way?
Right. Well, so the basic take a really extreme example, right? Let's imagine a prosecutor says to you that we have indicted you for this crime. Of course, you have a constitutional right to go to trial. If you go to trial and lose, we're going to put a bullet in every member of your family, but only if you lose. And then, of course, you'll also be sentenced to prison and so forth. It seems to me that any reasonable person, any moral being can see that that is a plainly coercive situation. And that the government is conditioning your exercise of your right to go to trial on essentially an intolerable outcome if you happen to lose. And innocent people are sometimes convicted. We know this. We know it beyond any shadow of a doubt. And so you're putting that person in the position of facing an intolerable dilemma. If they exercise their right to go to trial, but they're unfortunate enough to lose, even if they're innocent, which does happen sometimes, then every member of their family is going to be executed by the government. Again, I don't see how anybody could argue that that is not a coercive proposition that the government has made. So then the question is, okay, that does not happen in our system, but things that are not too far from that happen. And the main driver, or maybe the main dynamic in coercive plea bargaining, is the so-called trial penalty. And this is the differential between the punishment that the government threatens you with and follows through on if you exercise your right to trial and lose, versus the deal they offer you if you will go ahead and confess and plead guilty and spare the government the expense and inconvenience and the risk, I should add, of a trial. There is no limit whatsoever on what that differential can be in this country. There is a limit in other countries, but there's no limit on what that differential can be or what the government can threaten. Let me give you an example from a 1978 Supreme Court case called Borden-Kircher v. Hayes. In that case, the defendant was charged with passing bad checks. The range of punishment for that crime was 2 to 10 years. The prosecutor offered 5 years. The defendant said, well, I believe that I'm innocent. I want to go to trial. And the prosecutor said, if you insist on going to trial, if you reject this plea offer, I'm going to withdraw the plea offer and I'm going to go and get a superseding indictment. I'm going to indict you as a habitual criminal because the defendant had a couple of prior crimes. I'm going to indict you as a habitual criminal. And if you're convicted of that, the sentence will be life in prison. That is, I think, self-evidently coercive as well. That is not too far from the hypothetical I gave earlier where the government says, if you go to trial and lose, I'm going to put a bullet in every one of your family members. That case went to the Supreme Court, and in 1978, the Supreme Court, by a 5-4 vote, said there's nothing wrong constitutionally with what the government did in that case. In other words, saying to a defendant, here's your plea offer. If you don't take it, we're going to re-indict you under charges that will expose you to a vastly greater punishment than you were exposed to before, and we're going to do it simply because you turned down our offer. I don't see how anyone can look at that and not see how coercive that is.
Why didn't they indict him? If he was actually guilty of this crime and he was a habitual offender, why didn't they indict him for that in the first place?
Well, prosecutors, of course, have discretion to not indict people or to indict them only for some of the crimes that they believe they're guilty of. So prosecutors have completely unfettered discretion. I don't know because I wasn't involved in this case. It was back in 1978. But you could imagine that on some level the prosecutor basically felt that taking what he knew about the defendant and the circumstances of the crime, that a 2 to 10 year sentence range was appropriate, and that a 5-year sentence was basically just in this case, and that exposing the defendant to life in prison was both unnecessary and might even have been unjust. The real question is, why did the prosecutor then go and get this superseding indictment where he brought these additional charges that exposed the defendant to a vastly greater punishment? And the word for that is very simple. It was coercion. He's trying to leverage a plea bargain. The prosecutor doesn't want to go to trial. He's got lots of work to do. He's got lots of cases to process. He's got lots of people to run through the system. Trials are expensive, they're time-consuming, they're inconvenient, and they're risky for the government. So very clearly what he was trying to do in this case was coerce the defendant into accepting the plea offer to just keep things moving. And that's the lifeblood of American criminal justice, is coercion. That is how our system operates. It's the underlying kind of the motor that drives our criminal justice system today. We would not be able to process even a fraction of the defendants that we routinely run through the system if most of them did not plead guilty, because it saves a lot of time, it saves a lot of money, and that increases the number of prosecutions that you can pursue. And that's basically why prosecutors have become so addicted to plea bargaining, is that it vastly maximizes the number of people they can run through the system.
There's so many questions that brings up to me, and I'm going to try to I'm going to try to get them one at a time and hit them all, even though we don't have weeks to talk about this. So I know some prosecutors. I'm sure you know quite a few more, and the ones that I know, I generally think of as good people, and not the kind of people who are just out to put innocent people in jail or put guilty people in jail for excessive periods of time. So let's just run with your sort of surmise about what happened in the Bordenkircher case, that the prosecutor figured, 2 to 10 is probably about right. If we give him 5, that kind of that's a reasonable compromise, and to induce him to do that, avoid the 10, and just all the things you said. It sounds like it's a prosecutor looking at it in a fairly just sort of way, but then he doesn't get what he wants, and so he tightens the screws to an extreme degree. How do you fix that? Because I suppose you could take away the prosecutor's leverage on the habitual offender laws, so that then he doesn't have the ability to tighten the screws on the defendant in that way. So he's legislatively, you sort of take away some of the discretion by removing, changing the penalties for what the crime, at least the alleged crime, was. But it's not clear to me how you fix a problem of a prosecutor who's we'll give them the benefit of the doubt and say they want to do the right thing and say we think this is the right sentence, but then they don't get it. How do you stop them from then getting coercive?
Right. It's an incredibly important question. It might be the most important question in all of criminal justice. And I need to preface it with a pretty stark metaphor here. If you're looking at criminal justice and criminal justice reform, I think that basically what you're looking at is think of medicine, think of a doctor's office, think of a patient in the doctor's office who has an extremely aggressive form of cancer that is fully metastasized throughout the body, stage 4 or 5, and this cancer is highly resistant to chemotherapy and to radiation and to all of the drugs and therapies that are known. And ask yourself, well, what would be the right medication for this patient? What's the best thing to do for this patient? Yes, you should be asking that question, but you also ought to be very aware that you're asking it in the context of, this is an incredibly sick person who's got an incredibly aggressive and resistant disease, and it will be perhaps on the order of a miracle that if we can, to save this person's life or even to extend the life for very long. I think that is not an overly extreme example to use for our criminal justice system, because the rot and the pathology is so profound and so deep, and the manifestation of plea bargaining and the way that it's done and the way that it's come to take over our system is I think one of the most important pathologies in the system. Think about this. Think about regimes throughout history that have excelled at extracting confessions from people. You're going to think about the Soviet Union. You're going to think about North Korea. You're going to think about the Spanish Inquisition. And you know who you're going to put at the top of that list? You're going to put the United States. We don't use the same techniques, but we use on balance the same methods, and the methods are coercion. And we've barely scratched the surface in terms of the coercive tools that are available to prosecutors to get people to confess and accept a plea bargain. Let me just touch on a few of those. So first, you've got pretrial detention. Jail, which is where you are before your trial, is an incredibly unpleasant place to be. And in some places in America, it's hell on earth, like Rikers Island in New York. It's also very difficult to participate in your defense when you are locked up pre-trial. It's hard to meet with your lawyer. It's difficult to go and find evidence that might exonerate you, to provide phone numbers and contacts and documents that might assist your lawyer in putting together your defense. And that is by design, not by accident. So for people who are locked up pending trial, it's right out of the box. You're going to have a very hard time in participating in your own defense, which is going to provide leverage to the prosecution.
If I may, let me interrupt you there. You said it's by design and not by accident. How do we know that?
For a couple of reasons. First, there's in many jurisdictions, prosecutors are emphatic about insisting upon money bail, even for people who they don't have any credible argument are a threat to the community. So they will try to keep people locked up merely on a suspicion of having committed a nonviolent crime. I can't think of any other plausible explanation for that than, essentially a desire to make it as difficult for them to put on an effective defense as possible. We can only surmise.
Sure.
I mean, yes, I do. As you suggested earlier, I do know prosecutors, and the ones that I know, I consider good, decent people who happen to be working in a system that is much more broken and morally problematic than I think they really realize. But in some sense, on a day-to-day basis, if you just look at it in a certain way, it's possible to see them as engaged in a virtuous and legitimate project. There are bad people in this country. There are people who need to be taken off the streets. Prosecutors, in their own minds, and to some extent in reality, are focused on trying to protect the rest of us from those people. So far, so good. The problem is in the mechanisms and the tools that have evolved to get that job done, and the level of denial that most prosecutors have when it comes to the significance of that suite of tools. And let me go back to them. So we've got pretrial detention. The second step, and this is something that you and I as litigators, and I'm a former litigator, litigated for more than 20 years, both in private practice and as a constitutional lawyer, but you and I are very aware of this. It's the efficacy of the advocacy in this area. About 80% of people who go through the criminal justice system are represented by government-paid lawyers, either public defenders or lawyers who are working on a kind of a government-funded voucher. They're wildly underpaid. They typically are wildly overworked. And so they really don't have the bandwidth or the resources to provide a fully effective defense to every one of their clients. And there's yet another factor, and this is something, if you get to know a public defender well enough to have this conversation with them, it's quite shocking. But the ones that I've spoken with freely acknowledge that the following is another aspect of the problem, and that is, when you have a public defender who is a repeat player in the system, they've got a dozen or maybe even hundreds of cases pending at any given time. The way those cases are going to get resolved, most of them, is through plea bargain. And that public defender needs to ensure that his or her clients get the best offers they can. How does he or she do that? By being on good terms with the prosecution, by being friendly with those prosecutors, or at least not being as adversarial as they are supposed to be. And that has a very significant impact on the quality of advocacy, because what that does to public defenders is it puts them in a position where they have to not be perceived as unreasonably digging in their heels and filing motions on behalf of their client, or insisting upon trials when they don't have a super strong defense just because their client wants to go to trial. So there's a great deal of pressure on public defenders to be perceived as reasonable by the prosecutors that they have to deal with in this fundamentally transactional process of plea bargaining. And I have been told by multiple public defenders that it absolutely does affect both the quality and the nature of the advocacy that they provide, because they understand that their primary job is to make deals for the vast majority of their clients. And in order to do that, they have to remain on good terms with the prosecutors to continue getting high quality offers. That's hugely problematic. And that also increases the prosecutor's leverage when he or she knows, or at least can surmise, that the lawyer on the other side of the case has this conflict, has this need to appear to be reasonable. And a likelihood, that they'll accept reasonable offers, or at least they don't have the ability to accept, of course, but that they will tell their client that they should accept these offers. So now we've got pretrial detention, we've got under-resourced and potentially conflicted defense counsel, we've got the trial penalty that we discussed earlier, which is part of this kind of overcharging situation where prosecutors can think about a simple crime like somebody goes into a sporting goods store, grabs a pair of sneakers, and runs out the door, maybe pushing the security guard aside as he leaves the store. That's shoplifting. That's shoplifting. A $100 pair of shoes. That's probably a few weeks in jail, if not deferred adjudication or something like that, if that's the way it gets charged. But you know what a prosecutor who wanted to be creative could do? And also to exert leverage, that prosecutor could charge a bunch of other crimes in that situation. He could charge it as a robbery because of even the minimum amount of force that was used to push the security guard out of the way as he runs out of the store. Now you're looking at something that's not a few weeks or months in jail. You're looking at something that is years in prison. And they can get incredibly creative, and there are no restraints whatsoever on the prosecutor's ability to stack up charges in the way that I just described in order for the explicit purpose of increasing their plea leverage. And they do it all the time. It's part and parcel of how prosecutions work in this country. And so I'll stop listing all these levers that prosecutors have available to them, but there are many
There's a
others
large toolbox they carry around.
Exactly. It's a gigantic toolbox. Now, let's go back to the profound question that you asked earlier. How is it that good, decent people who become prosecutors and believe that they're doing the right thing can kind of get caught up in this fundamentally coercive process that I believe is so pathological and rotten and immoral? And I think the answer is this. Once it becomes the default expectation that most criminal cases should be resolved by plea bargain, and that's absolutely the case in every prosecutor's office in this country, whether they admit it or not, because the vast majority of people who've been indicted end up pleading guilty. That's just the way the system has come to work. Then as a prosecutor, think about how you're going to look if you have a vastly lower plea bargain rate than your colleagues, and you're having to take far more of your cases to trial than your colleagues do. So you're constantly out of the office. You're constantly over there in court. You're constantly draining resources from that office. Oh, I need to have the police officer who arrested this guy come and testify. I need a money for an expert. I got another guy going to trial, so I'm going to be out next week as well. Meanwhile, all of your colleagues are basically sitting at their desks, obtaining convictions with no more than a few emails or phone calls, wrapping that up maybe in a couple of hours. And they're getting, let's say, 10, 20, 30 convictions a week through plea bargaining, and you're lucky if you get one a week because all your cases are going to trial. You think you're going to be hearing from your supervisor? You better believe it, because you know who your supervisor is going to be hearing from? They're going to be hearing from the judges who are saying, what is up, with this guy who can't get his people to plead guilty? Everybody else in the office is getting people to plead guilty. Maybe you need to talk to him about whether he's making full use of the tools that are available to induce these pleas, because it doesn't look like it. If you don't think those conversations happen, you're naive and you're dreaming. Those conversations do happen. And my surmise is that people who tend to thrive in that job are the people who are most willing to make the most use of the tools that are available to essentially do what has become the primary modern day business of prosecutors. And that is getting people to confess to crimes and enter into plea bargains. They're not trial lawyers anymore. They're not investigators. Their primary function in our system of government is getting people to plead guilty. That is basically what the fundamental job of prosecutors has become. And if you're not good at that job, you're probably not going to last very long as a prosecutor. That's my sense of what's going on now.
So it seems to me, in order to fix this problem, there's a couple of levers, tools in the toolbox to fix the problem, and none of them are very attractive that I'm thinking of. One, we pour tons more money into this because if we have a lot more, say we go from 90 or 95% plea bargainings and drop it down to 50, which still that's half of the cases that plea bargain. That's going to require a lot more prosecutors, I would think. It's going to require a lot more money to pay defenders, public defenders, or court-appointed lawyers, and of course all of the other, more judges, more courtrooms, more all of this stuff. So the one lever is throw a whole lot more money at it. The other is to have a lot fewer prosecutions, which may mean we just demand that prosecutors use their discretion to prosecute less. I don't know how we demand that when it's their, that they have the discretion there, or we have to change a lot of laws to decriminalize a lot of things that we, at least at this point, we've spoken through the legislature and said that ought to be a crime. Are there other levers besides more money and fewer prosecutions that I'm missing to fix the
good
problem?
news is yes, there are. The challenge is that the law enforcement community, if you kind of think of police and prosecutors as a community, the law enforcement community is probably the second or third strongest political lobby in the whole country, second only to public school teachers, as far as I can tell. And so, if you talk to people over on Capitol Hill, for example, about the amount of influence that the U.S. Department of Justice exerts in the legislative process, it is flabbergasting. It is astonishing how influential the DOJ is over on Capitol Hill. And so, in terms of thinking about reforms, you have to think of it on two levels. First, you have to think about what would be effective if you could get it done. But second, you have to think about, well, what are the prospects of getting this done, given that the law enforcement community may perceive this, probably would perceive it, if it's a really effective reform, as a threat to the way they do business as usual. People get comfortable with the way they do business as usual, including police and prosecutors, and they tend to be resistant to change that appears more favorable to other people than to them. So I have some ideas that would be great in a kind of an abstract, in the abstract, but I think are politically unlikely, just because of the extraordinary amount of influence that police and prosecutors have over the system. And then I've got some ideas for changes that can be imposed on the system from outside. So we can talk about both of those. First, if you had confidence that you could get certain reforms through, the three things that come immediately to my mind, one of them you've already touched on, would be to increase the resources on the defense side, so that every defendant could credibly receive a fully zealous defense. Every single public defender should be able to plausibly represent to the prosecution that he or she is prepared to take the case to trial, regardless of its apparent merits. That would be first. Second is I would cap the amount of discount that prosecutors can offer by way of plea bargaining. That would not completely fix the coercive nature of plea bargaining, but it would take a major lever away from prosecutors. And there's precedent for this. Actually, in England, for example, there's a maximum of a 30% discount. So if you're an English prosecutor and you indict somebody for crimes that have them looking at 10 years, the most you can offer them by way of plea bargain is 7 years. You can't go lower than that. That should absolutely be part of our system, and I think it would be absolutely prosecutors would fight tooth and nail against that kind of a cap on the discount. But we should do that. That would help to eliminate, or at least to mitigate, the trial penalty. The third thing that I think you would do, besides increasing the amount or the zealousness of the efficacy and reducing the trial penalty, would be to change the incentives in prosecutors' offices so that they don't simply get credit per conviction. They're evaluated on the quality of the conviction, and make it clear that the prosecutors who bring charges against and obtain convictions against genuinely bad people who represent a true threat to society, will be taken care of, and basically will receive both promotions and compensation in accordance with the quality of the convictions that they get. So that basically, if you're a prosecutor and you just want to do a bunch of low-level drug prosecutions, your career will go nowhere. Whereas if you're a prosecutor that really works hard to get the high-level convictions, taking these MS-13 people off the streets who do horrible things in their communities, then you're going to get you're essentially going to get promoted and compensated accordingly. We got to change, in other words, to change the incentives under which prosecutors operate. And I guess I'd add a fourth thing too, and that would be open file discovery. Open file discovery should be the rule, and I don't want to get too involved in what that means, but the gist of it is this. Unlike civil litigation that you and I are, and probably a lot of your listeners are familiar with, where there's abundant discovery, there's all kinds of tools and mechanisms available to try to, essentially get at the facts of the case. You get to look at the emails that the other side has, and you get to look at, for documents, you get to take depositions to find out what people think about certain issues, et cetera, et cetera. There's very little of that on the criminal side. And in fact, both at the federal level and in most states, the defense has no real opportunity to learn the true nature of the prosecution's case, who their witnesses are, what they have to say, et cetera, until right before trial. They'll get disclosure of witnesses. The other thing that's a huge problem is the Supreme Court has... Go ahead.
You say right before trial. How long before trial?
Well, it depends on the jurisdiction, but New York, for
Sure.
example, New York is notorious for dumping information that defendants are entitled to literally on the eve of trial.
Wow.
And with the explicit purpose, of course, of impairing the defense's ability to put on an effective case. There's another wrinkle to this too, which is in a case called Brady from the 1970s, the Supreme Court held that there's a constitutional requirement for prosecutors to disclose materially favorable evidence to the defense. This would include things like genuinely exculpatory evidence, like the prints on the gun did not match or the DNA doesn't match, but also includes impeachment evidence. For example, the prosecution's star witness has been held in other proceedings to have lied or has significant biases. Like, for example, there is a snitch who's been offered a deal by the prosecution, the reduced sentence or even to dismiss charges if they'll testify against the defendant. So all of this information is prosecutors are constitutionally obligated to disclose to the defense as so-called Brady material. And there's a very strong indication that there are persistent Brady violations in our system. Prosecutors will say that's not true. The problem is we really have no way to know. But because so few cases go to trial, the process is quite opaque. We just have to sort of take their word for it. But there are so many. Put it this way: there are so few opportunities to find out whether the prosecution suppressed Brady material that when we do see it, we can extrapolate. If we see, let's say, 1 out of 200 cases, we see a Brady violation. It's entirely fair to extrapolate that to some much higher number because we have so few opportunities to actually, see the process unfold in public the way the Constitution said it's supposed to. Why? Because most of these cases are resolved through plea bargain, and we never get to see the full public, presentation of the case. So that's another huge problem in the system is this some number, and there are many people who think it's an epidemic of Brady violations. So those are a few ideas for reforming the system. Essentially, increase the resources available on the defense side. Open file discovery, so defendants have a better ability to look into the government's case and kind of see what's coming, the way we get to do in civil litigation. And then third, mitigate the trial penalty by putting a cap on the amount that prosecutors can discount between the threatened sentence and the sentence they offer if the person agrees to confess and plead guilty. Those are those are reforms that would have to be, you'd have to get that past the law enforcement lobby, and I think it would be extraordinarily difficult to do. I have a separate set of reforms that could be imposed from outside that we can talk about.
And I want to hear about that, but I have a question about the capping the discount that can be offered. Is there a way that can be, like in the Bordenkircher case, where the prosecutor was threatening additional charges for crimes that would have a greater sentence? Is there a way that that this capping the discount that can be offered can apply to the threat to, if you don't plead to this offense, I'm going to charge you with this more severe offense?
Right. So there's no perfect way to do it. But one way to do it would be to say that essentially the prosecution cannot go and get a new indictment absent some extraordinary reason that has nothing to do with simply increasing the amount of leverage available to them. So you'd essentially put judges in charge of overseeing this process. And to take the Bordenkircher case, imagine that the prosecutor shows up in court and says, "Well, Your Honor, I'm going to file a motion to file a superseding indictment." The judge would say, "Well, as you know, you're required to have a compelling explanation, in terms of, maybe a new witness or late discovered evidence or something." And the prosecution would have to show to a fairly high degree of certainty that the decision to try to get the superseding indictment was motivated by something other than just trying to, impose or bring leverage in plea negotiations. Now, of course, the problem is that the likely response is that prosecutors will just bring everything they have. They'll kind of throw the full toolbox or the full set of charges at defendants, and then we'll have we'll have to respond to that in another way. And actually, one of the things I'm going to suggest for how we impose change from outside would in fact help to ameliorate that likely prosecutorial response of, okay, fine, if I can't go and get a superseding indictment, I'm just going to throw the whole boat at you all at once, right off the bat. But I have an idea for how to mitigate that we can talk about.
Yeah, go ahead. I want to hear the ideas for imposing change from the outside, and also define the outside there, if you would.
So the outside is essentially ways that we can basically affect change in the criminal justice system over the objections of the law enforcement lobby. So some other way than going, for example, and asking legislatures to change the law, or asking judges to change the procedures, or whatever, just literally change that can be imposed unilaterally. And I'll give you two examples. One of the most surprising things I learned when I started doing this job a couple of years ago and really delving into how the criminal justice system actually works is the number of people who have basically made it impossible to defend them because of something they said or did during their initial encounter with law enforcement. Go and talk to any criminal defense attorney and just ask them how many of your clients have essentially destroyed their own case before they ever walk in your office. And I've probably asked 4 or 5 dozen criminal defense attorneys that question. I get the same answer every time. You get kind of a rueful chuckle.
Yeah.
And they'll say, oh, most of them. The consensus figure is well above 50%. So why does this happen? I think the reason it happens is because police have become incredibly adept at getting people to say or do things that are in the interest of the police, but not the person, not the suspect, during that initial encounter. They use a variety of techniques. They will use, they'll cajole. They'll appear to be friendly when they're actually not. Listen, it's not a big deal. Just talk to me about what's going on here. I can smell it on your breath. You've had a few drinks. Just tell me. Listen, maybe I don't even write you a ticket. Just tell me what's up. So that's cajoling. Many police will just use outright deceit. You can go on YouTube actually and see any number of videos. There was a kind of an infamous example where happened recently where an Uber driver was stopped in North Carolina, and he recorded the stop. He pulled out his cell phone and started recording the stop. And the police officer told him that there was a new law in North Carolina that made it illegal to record traffic stops, and so he needed to put away his phone. So first, that was completely false. There is no law in North Carolina that prohibits that. There are wiretapping laws in a very small handful of states that purport to restrict people's ability to do that without the permission of the police officer. But it turns out there's actually a growing body of case law that says that there is a First Amendment constitutional right to record that encounter. There's about 5 or 6 federal circuit courts that have held that there is a constitutional right. I think that issue will soon get to the Supreme Court, and so it'll be resolved once and for all. But pretty clearly and plainly, there is a constitutional right to record, and this police officer lied about that. So that's another way that police officers can get people to confess or to agree to a search or whatever it might be. And they're very effective at it. When I say police have become very, very effective at getting people to make admissions, to waive constitutional rights, to agree to a search, et cetera. And sometimes they just use outright intimidation. I mean, just naked threats, of harm to the person. A classic example would be, I want you to agree to let us search your car. And then the answer is no, I'm going to assert my Fourth Amendment right not to let you search my car. And then the response is, okay, well, I'm going to have to get a drug sniffing dog out here. And we both know that dog's going to alert when he smells your car. Because that's, by the way, that's what drug sniffing dogs are trained to do. They're not drug sniffing dogs. They're probable cause creating dogs. I call them PCC dogs because that's their true function, is to alert in the presence of a car so it can be searched. And what police will sometimes say overtly or between the lines is, if you don't consent to this search and you make me bring the PCC dog out, your car is going to look a lot different when I'm done searching it than it does right now. A lot different. The interior is going to be quite a bit more messed up than it is right now. And I've talked to any number of people who said they've had that exact conversation with police. So there's this whole sort of variety of things that police can do to get people to say things that are against their interest or consent to a search, et cetera. Okay, how can we impose change at that point? What if we had a way for every single person to receive free live legal advice in that setting? So my wife we were driving to work a few months ago, and she got pulled over for speeding. And it was a classic speed trap. It was a off ramp from a highway where everybody's going 60 miles an hour, and the off ramp suddenly went down to, I think, 25 miles an hour. And the police officer was exactly on the other side of that of that, speed limit sign.
You're right.
Just like a bear at a salmon stream, So I'm sitting next to her. I'm pretty knowledgeable about Fourth Amendment procedure and criminal law and so forth and so on. And, it went down the way they always go down, or at least they usually go down. The police officer comes to the window. He was very nice, by the way, comes to the window of the car, asks to see her license and insurance, goes back to his squad car to run the information. So I think it would be very obviously a constitutional violation, definitely a First Amendment violation, maybe also a Sixth Amendment violation. If that police officer looks at me and says, "Excuse me, sir," sitting there in the passenger seat, what do you do for a living? And I say, well, I do criminal justice reform. I'm a lawyer. And he says, okay, well, while I'm back in the squad car running your wife's information, you can talk to her about anything you want, but you can't give her any advice about how to handle this situation. Totally unconstitutional. So now imagine I wasn't sitting in that seat, but instead she happened to, when she saw she was getting pulled over, she tells her smartphone to dial my number. So now I'm on the phone, and I'm just listening in and prepared to help however I can, but I'm not in any way interfering with police officer's investigation or, distracting my wife or anything like that. I'm just listening in case he says or does something that sounds out of line to me, and then I can kind of step in and give her some advice. Again, totally unconstitutional for him to try to shut that down. Again, as long as it's not in any way interfering with his investigation. Okay, well, there you go. That's the whole thing in a nutshell. Why on earth couldn't we just make that available to everybody? When you get in a car accident, we send an ambulance. We don't ask for your insurance. We don't ask what your financial state is. We don't, insist that you meet some kind of, financial responsibility requirement. We just send an ambulance. Well, why not treat involuntary encounters with law enforcement like that and say, look, nobody should have to talk to a police officer without legal counsel, and we can do that. We can provide that. And I'm convinced that we can. And I've actually been working on an app that would do exactly this. And think about it. All you really need is somebody who's reasonably knowledgeable about the legal issues at stake. They don't need to be an expert criminal defense attorney. They just need to be able to do more help than harm, to be on the phone with somebody while they're interacting with the police officer to help them know what their rights are and have the wherewithal to assert those rights. So what that's going to do is it's going to vastly drive down the number of people who make an admission or agree to a search or take some other action in that setting that makes their case a slam dunk for the prosecution. And by the way, I'm not proposing this because I want people to get off the hook who are guilty. I'm proposing this because I want the government to have to work as hard as the Constitution says it's supposed to have to work. I don't want there to be any more low-hanging fruit. I want police and prosecutors to have to dot all the I's and cross all the T's and not resort to this kind of informal system of playing games with people where they get them to, give up their constitutional rights in a way that
I think that's one of
law
the
enforcement, but not the suspect.
That's one of the big challenges, I think, in talking about these issues to the general public. Is their initial response is you're soft on crime, you're going to make our communities more dangerous, you're going to let bad people go, and the default assumption in the general public is that, I think, two things. One, innocent people don't plead guilty. They don't admit to having done things that they didn't do, which we know is false, but you and I know it's false because you for sure pay very close attention to these things, and I'm sort of on the periphery of paying attention to them. But the other thing is, we assume that if you're not guilty, the system will work and you will be acquitted, if not fully exonerated. But I think both of those, the two things I'd like to ask you about there. One, just quickly tell us, for those of us who don't necessarily follow this the way you do, what's up with people who actually plead guilty to things they didn't do, including, the Bordenkircher case. You have this vast disparity between what he's facing if he doesn't plead guilty and an acquittal. There's a huge difference there, and they're really turning the screws on him. But I don't think that's the only. It doesn't have to be that onerous and that coercive for people to confess to things that they didn't do. Am I right about that?
Yeah, no, you are. And look, one of the most important questions that should be keeping every single person up at night is, are false confessions rare, which is what prosecutors would tell you, that they hardly ever happen, or are they routine, which I'm increasingly of the mind that they are, or somewhere in between? There's a group called the Innocence Project, which is a nonprofit that seeks to exonerate convicts, people who've been convicted of serious crimes like murder, rape, things like that, using DNA evidence. It's not perfect, but it's as close to perfect as we can get. It's the most reliable method of exonerating somebody known to man right now. And you can be pretty confident when somebody is exonerated with DNA evidence. If for example, they were convicted of a rape, and that the primary evidence used against them in trial was that there was a match between their genetic material and what was found in the victim. And then it comes, and that's how they were convicted. And then, maybe you do a better test, you get a more reliable test, or somebody admits that they switched the sample, for example, or whatever. But you essentially are able to show that, in fact, there was not a match between the defendant and the material found on the victim. It's as close as you get. And it is astonishing how many people who have been exonerated by the Innocence Project, in fact, pled guilty. And it's somewhere between 10 and 20%. So you got between 10 and 20% of people who have been convicted of very serious crimes like rape and homicide, who are later exonerated using DNA evidence, which again is not perfect, but it's pretty close. And what we discover is that somewhere between 10 and 20% of those people who were falsely convicted actually pled guilty. And we get similar results, for example, when there's a drug lab scandal, which has happened in Houston, it happened in Los Angeles, it happened in Massachusetts. So you'll get a drug lab scandal or some other issue where you find out, for example, that the test that they were using to determine the presence of illegal drugs was a bad test that didn't work. And in Houston, this happened pretty recently. Houston had a practice that is unusual, which is that they retained samples. They retained the drugs upon the alleged drugs that somebody supposedly had on them, and they discovered that the procedure they were using, which was essentially to proceed with an indictment on the basis of a relatively inaccurate field test. And then if they could get the person to plead guilty, they wouldn't even go ahead and do the more accurate laboratory test. They would just, say, okay, well, we did a field test, tested positive for the presence of whatever, heroin or meth, and this guy agreed to plead guilty, so case closed. What happened was that for whatever reason, they decided they went ahead and tested all these drugs that they had retained after somebody pled guilty, and they determined because they learned that their field test really wasn't very good. And when they subjected those drugs to a more reliable laboratory test, what they discovered is that a very significant portion of the drugs weren't drugs at all. And something like 65% or more of these people who were then exonerated because it was determined that they never had drugs, or at least that the particular substance they were accused of illegally possessing at the time turned out not to be drugs. Something like 65% of them pled guilty. And so we don't know how often it happens, but we know it happens a lot more than we're led to believe. Here's one more.
It's counterintuitive because we all think, oh, I would never do that.
Yes, and let me make 2 points about that. First, you're wrong. If you think you would never do it, you are wrong. And we know that in part because there's been a number of laboratory experiments that have tried to sort of recreate the psychological dynamics of being falsely accused and then offered a deal. And so, for example, they'll take a bunch of college students and they'll have them engage in some kind of a project. And they'll be warned that if they cheat, it'll be a big deal, et cetera, whatever. And then they go in and they falsely accuse some of the students of cheating. And they'll say, we've been videotaping the whole thing and we saw you cheat. So we're going to have to report you to the honor, the honor disciplinary system or whatever. It is amazing how many people, and then they'll offer them a deal. They'll say, well, listen, if you'll just admit that you cheated, we'll make a note of that. You won't be able to participate in these experiments anymore, but that'll be the end of it. It is astonishing how easy it is to get people to confess to things that they didn't do under laboratory settings. And there's every reason to believe it's even easier in the real world, where the government has the ability to bring far worse consequences to bear. I mean, we're talking about somebody who's just a college student in a laboratory experiment. That's the hypothetical. But in real life, what we're talking about is somebody who's rotting in jail, maybe in a very dirty, dangerous place, knowing that they're going to get an inadequate defense counsel and being told by a prosecutor, look, I'll let you out with time served if you agree to plead guilty, but if you don't, you're going to be looking at 10 years. What do you want to do? If you think you wouldn't confess under those circumstances, I'm sorry, but you're fantasizing. And if you think if you think what I just described doesn't happen every single day in this country, then you need to educate yourself, because it does. Second point. So when we're looking at this question of how do false confessions happen, First of all, we know that prosecutors have an extraordinary coercive suite of tools available to them that they routinely bring to bear on people seeking to elicit confessions. Why? Because that's the way the vast majority of criminal cases are resolved in this country, and it's come to be the default mechanism. So prosecutors know they've got to apply these tools in order to get confessions because that's the expectation, both of their supervisors and of the judges that they will have to appear in front of if they fail to get a confession. So for trial. So here's something that's extraordinary to me. I started off at a big firm in Texas as just a civil defense lawyer. I did civil litigation mostly on the defense side, and among other things, I did a fair amount of medical malpractice defense work. And my sister's a doctor, and I know a fair amount about hospitals and doctors and litigation and et cetera. My father was a NASA engineer. He helped put a man on the moon. He was an aerospace engineer for many years after that, so I know a certain amount about the aerospace industry. One thing that medicine and aerospace have in common is that there are certain outcomes that they don't just try to minimize. There are certain outcomes that are considered to be intolerable, that you don't just try to minimize the number of times something happens, you try to prevent it from happening ever. And in commercial aviation, of course, it's a plane crash. There's no standard that says, well, let's try to keep plane crashes down to, lower than 1 in 1,000. You try to prevent them altogether, right? Same thing in medicine with acts of really significant malpractice. I'm talking about things like somebody goes in, a diabetic goes in to have her right foot amputated because of, circulatory problems. And instead they amputate the perfectly healthy left foot. Guess what? That happens. Hospitals don't try to minimize the number of times that happens. They try to prevent it altogether. In criminal justice, there's a very obvious outcome like that, and that is the false conviction, and more specifically, the false confession that leads to a false confession. That should be treated just like a plane crash in commercial aviation or a really serious act of malpractice, like amputating the wrong limb. Everybody involved in a case where there was a false confession that resulted later in an exoneration, everybody involved in that case should stop what they're doing, literally put down what they are doing, get together and do what they do in medicine and aviation, which is called a critical incident review. The point of a critical incident review is not primarily to figure out who's at fault or what should happen to them. It's to look at the process that allowed the intolerable outcome to happen and figure out how does that process need to be changed so that that intolerable outcome never happens again. In every single field of human endeavor that I'm aware of, where you've got tremendous risk at stake, when the outcome of something can be intolerable, like somebody losing the wrong leg or dying by getting the wrong drug prescribed or a plane crash, every single field of human endeavor that I know of where there's that kind of risk at stake, they have some version of this critical incident review process to ensure that when an intolerable outcome happens, they figure out what it was about the system that allowed it to happen and fix it. The one field in which I'm aware that it doesn't happen is, guess what? Prosecutions. Prosecutors have no critical incident review process that I am aware of. They have conviction integrity units, but that's a completely separate thing. Conviction integrity units are basically groups of prosecutors who try to identify people who've been wrongly convicted and get them exonerated, which is a absolutely worthy and important activity. But it's not the same thing as taking a systemic look at your process to figure out why the intolerable outcome happened and what you need to change in order to make sure that that thing never happens again. There is no prosecutor's office that I'm aware of anywhere in the country that has anything like a critical incident review, and I think that tells us a tremendous amount about the culture in that profession. It is completely different than the mindset of people in a hospital or the mindset of people who run airlines in terms of their acceptance of these intolerable outcomes. Intolerable outcomes are not accepted in aviation. They are not accepted in medicine. They are absolutely accepted in criminal justice. Maybe with a certain amount of hand-wringing, but accepted nevertheless. And I think that speaks volumes about the system itself and why it operates the way that it does.
We only have a couple minutes left, but there's a couple of quick things I want to get your take on. So, we've both referenced that we have some experience doing civil trials. I'm on the plaintiff side, and every time I try a case, I am pounding on the jury. Well, not on the jury. That would be counterproductive. I am trying to make very, very clear that my burden of proof is by a preponderance of the evidence. And I talk about the 51%. And The preponderance, it simply means more likely than not. And I go over all of these different ways to think of the preponderance because I have a very low burden of proof. And I talk about you can have 49% doubt as to my client's case, and you still vote for my client because we're the plaintiff and that's our burden. That's different from the criminal context where it's beyond a reasonable doubt. I don't know of a percentage that any court or anyone has put on that, but it's beyond reasonable doubt. A, has it been very well defined by the courts? And B, how seriously do you think the public, and more specifically the public who ends up on a jury, takes it? And one of the things I think about, I have a friend who went and watched a criminal trial. It was a serious trial, a serious crime that was charged. My friend didn't have any particular affiliation that would make him sort of be cheering for prosecution or acquittal, or conviction or acquittal, I mean. And at the end of it, and I think it was over a week-long trial. At the end of it, he was telling me about the evidence, and he thought, yeah, I can certainly see where someone thinks he did it, but I don't know. And he even sort of had overheard the prosecutor talking to the defense attorney while the jury was deliberating. He said, yeah, I don't think we're going to get this one. The jury comes back with a guilty verdict. There's a great scene from Idiocracy, the courtroom scene, where the judge starts out and he says to the prosecutor something like, tell us why you think he done it.
Yep.
And I worry that that's kind of the popular view of, okay, we'll convict him because we think he done it.
Right.
Is there data on that? What can you tell us about how seriously the beyond reasonable doubt standard's taken?
So it's a great question. I'm glad that we're kind of going to end on this subject because I believe that the jury is the most promising reform, or that the reinvigoration of the criminal jury is the most important thing we can do. And it's a change that can be imposed from outside. We talked about that a bit more. This is the major change that I would impose from outside. Let me tell you how. So the first point is this: juries are not perfect. I've had jury trials. You've had jury trials. We've seen how they sometimes work. It's not always a pretty picture, but it's better than anything else. Try to come up with any other way of essentially adjudicating a person's guilt or innocence. And the problem is that you're essentially, ultimately, every other way besides a jury is going to leave it to some extent up to the government. Whether that's the prosecutor or a judge or some panel of government experts or whatever. And that's intolerable because eventually those people are going to identify with their employer. And the problem with leaving it with the government is the government's the one who initiated the prosecution. They already think that you are guilty. In fact, they're sufficiently convinced that they're putting a bunch of resources into trying to convict you. They wouldn't do that if they had some doubts about it. So they're sure you're guilty. The question then is, okay, well, who are we going to bring in to decide if they're right? And there's really no other way that's been discovered to avoid this problem of what's sometimes referred to as capture, that essentially anybody who's working for the government, who's brought in to help make this decision, is eventually going to sort of, come to align with the government. There's no other way to do it. So yes, juries are imperfect, but they're less imperfect than every other mechanism that has been devised. And so that's point one. Point two is, if you had to identify the single greatest pathology in our criminal justice system, I would say it is this. If you look at the text of the Constitution, you cannot fail to see that the framers of the Constitution decided to put citizen participation in the administration of criminal justice at the very heart of our constitutional scheme. The Bill of Rights spends more words talking about juries than any other subject, and the jury trial, the criminal jury trial, is the only right that's mentioned in the text of the original unamended Constitution and the Bill of Rights. So it's really important. They made a really conscious effort to ensure that before the government can convict somebody of a crime, they have to go through a citizen jury. And we've basically eliminated it. The criminal jury is practically extinct in America, and it has been a disaster. Yeah. So how would I fix it? Here, really quickly, here's how I fix it. There is nothing that prosecutors fear more than a properly informed jury. And by that, I mean something very simple. The way that juries were informed during the founding era, I like to call it a founding era informed jury. And founding era informed juries knew a couple of things that modern juries rarely do, and that judges and prosecutors go to extraordinary lengths to keep them ignorant of. And two of the most important things are this: the consequences for the defendant if they convict. In other words, what's the government going to do to this person if you convict him? How long is he going to go to prison? What are the collateral consequences going to be in terms of deprivation of civil rights, et cetera, et cetera? Juries in modern cases almost never know that. Back during the founding era, they typically would know that. The result was that the prosecution during the founding era had to make both a procedural case, like an empirical case for the person's guilt, but also a moral case that the jury should convict and that what the government plans to do to this person is morally just. And if the jury felt that it was not, they could engage in something that we call conscientious acquittal, sometimes referred to as jury nullification, but that's a pejorative and inaccurate term. Conscientious acquittal is what a jury does when they believe that the person is factually guilty beyond a reasonable doubt, but that what the government plans to do to that person as a result is morally unjust. And so the jury essentially says to the prosecution, look, you convinced me that this person is guilty, but I will not be part of what you plan to do to this person because it's too severe and it's not appropriate. Founding era juries knew all about conscientious acquittal, and they knew that it was one of the most important things that juries can do is to ensure that not only the prosecution is empirically valid, but that the proposed punishment is morally just. That has been completely cut off and is not a part of the modern criminal jury trial. And as a result, the modern criminal jury trial is less valuable than it used to be during the founding era. Why? Because that jury is not going to know about conscientious acquittal. In fact, during voir dire, the prosecutor is going to try to make sure no one ends up on that jury who believes in conscientious acquittal. And the judge is going to go to extraordinary lengths to make sure the jury doesn't know what the punishment is going to be and doesn't know that a juror has an absolute unqualified right to acquit a defendant who is factually guilty if they think it would be unjust to convict them. If we can restore that, if we can educate jurors that they can do all of those things and that they should know what the punishment is, and maybe even to tell them what the punishment is, just unilaterally. If my wife was sitting on certain kinds of criminal prosecutions, I would absolutely tell her what the range of punishment's likely to be, and she'd want to know because she's a libertarian too. So if we were able to reform the system in that way, where as in the founding era, jurors in modern criminal cases knew what the government plans to do with the defendant and also knows that it's an absolutely legitimate and indeed critical role of the jury to refuse to participate in unjust prosecutions, to refuse to convict somebody when it would be unjust to do so because of what the government plans to do with that person. That would absolutely transform our system, and it would make the risk of going to trial much greater for prosecutors, and the plea offers they give would start to look more and more attractive because they would know that if they can't get that defendant to plead guilty, they're going to have to go to trial in front of an appropriately informed jury. And I tell you again, nothing terrifies prosecutors more than the prospect of having to take a case to trial in front of a founding era informed jury who they will have to persuade that what they plan to do to the defendant is not just empirically justified by what the person did, but is morally justified. And modern day prosecutors are terrified of having to make the case that what they're trying to do to the defendant is morally justified because oftentimes they know they couldn't make that case.
My guest today has been Clark Neily, Vice President of Criminal Justice at the Cato Institute. Clark, thank you so much for coming on the podcast today and for all of the work you do in this field.
It's been my pleasure. Thanks so much for having me on the show.
This episode of the Personal Responsibility Lawyer podcast is brought to you by my law firm, Lovins Trosclair, where we use the civil justice system to hold people responsible for irresponsible choices when those irresponsible choices cause serious injuries and sometimes even death. We are personal injury trial lawyers, but we approach our cases a little differently than a lot of other lawyers who do the same basic kind of work. I really, really hope that you do not need us, but if you do need us, please call us before evidence gets lost. You can call us at 512-535-1649. Tell us you heard about us on the Personal Responsibility Lawyer podcast. You can also go to our website on the interwebs at www.ltlegalteam.com. That's L as in Lovins, T as in Trosclair, legalteam.com. We are here to help. Thank you for listening to the Personal Responsibility Lawyer podcast. If you like what you've heard or if you've learned something interesting, please do me a favor and rate the show on iTunes. It really does help. You can get more information about this show, including the show notes, at my personal website, michaellovins.com. And now I have to do some disclaimers where I say stuff that you already knew, but I got to say it anyway so that I keep the state bar happy. This podcast is not legal advice. You listening to this podcast does not make me your lawyer or you my client. Neither does it make any of my guests your lawyer. If you want me to be your lawyer, contact my office. If I can represent you, we will execute a written contract stating the specific terms under which I agree to represent you. Did you really need me to tell you that? I really, really hope not. Also, I am not certified by the Texas Board of Legal Specialization as a personal responsibility lawyer because they don't know what that is. They also have not certified me in any other areas of specialty that they actually do recognize. I think that does it for disclaimers. For Lovins Trosclair and the Personal Responsibility Lawyer podcast, I am Michael Lovins. We'll see you next time.